Hello, my name is Harold Furt Scott Roth here at the Hudson Institute and the Center for the Economics of the Internet. If we look at the largest corporations in the world, they all could be characterized as digital platforms. These are new corporations that have developed in the past few decades and have changed fundamentally the way that economies operate around the world. They're also subject to regulation, and we have with us today the world's leading expert on the regulation of digital platforms in Europe and Britain, and we're very, very pleased to have with us Suzanne Rabb. Professor Rabb is an independent barrister at Matrix Chambers. She has over 2 decades of wide experience in regulatory law, economics, regulation, and public policy. Her practice has a particular focus on the interface between innovation, trade, and economic regulation. She acts in matters involving governments, regulators, businesses across the regulated sectors, including communications, energy, environmental, financial services, healthcare, pharmaceuticals, infrastructures, TMT, natural resources, and other sectors that I can't even begin to list. We're very pleased to have with us Suzanne Rabb. Suzanne, you are going to tell us about regulation of digital platforms in Europe and Britain, and we very much look forward to your presentation.
Thank you very much. Thank you for inviting me to present to you today. So, as has already been mentioned, the approach that I'm proposing to take in my comments very much looking at a global phenomenon, but from the perspectives of Europe and also from the United Kingdom, where those perspectives may differ to some extent. So the insights that I propose to give today are really designed to draw on cross-disciplinary themes. I am first and foremost a barrister for the United States audience, an attorney or lawyer, but internationally I have experience from the economics and regulatory policy disciplines. So it's really trying to draw those perspectives together and try to distill some themes, but from my personal European and UK heritage. I'm sitting here in London as we speak. So I have a few slides which hopefully will provide some cameo relief as a substitute at the speakers. So if you will permit me to share my screen, I'm going to bring up backdrop, and for the next 45 minutes to an hour, we share with you my thoughts on evolving issues in digital regulation. I'll group my themes around these ideas of regulation, update on the current market environment, try to identify some of the emerging or pervasive following, but some of the specific challenges in digital platforms, and then to take a more through what might be some profitable areas of research. Just to share my perspectives on developments in this area, which is one that I have been charting clarity by professional practice. And perhaps one of the pervasive themes is that certainly an area that governments, businesses, regulators, others should have an eye on. But what we're not necessarily seeing is a emphasis to just what might be the appropriate instruments to regulate this area, and even how aggressive that regulation be. So the key debate here is one around considering whether ex ante proposed. So taking a more market-oriented approach to these topics, we would like to say that if the market prevails, then there should not be a need to act what there is observable harm. But in more recent years, there has been a much greater focus on taking earlier action, and that has been aligned at sector regulators, economic regulators usually employ, and based on the idea that certain market environments are close to natural, or such power over a marketplace that it isn't sufficient to rely on control or antitrust to protect those partners. They're a little bit more late about what they actually need in understanding those. And the idea here is that certain platforms, players, occupy significant that we aspire to status, whether it's gatekeeper status. And much of the debate, which observers may be familiar with, is a focus on certain global platforms, Facebook, Amazon, Microsoft, but not necessarily those large players. In our lives is very clearly present, but an increasing focus on other tiers of players who are significant, operate often at global scale, and inviting the inquiry as to whether other players, and I'm using the new term players rather than platforms, that are familiar with, whether it's taxi, whether it's booking a place to stay, through Airbnb, and so forth. Whether those now reach that similar tools need to be deployed. But is it true to say that one among grouping of platform means that a couple of regulation and control deployed? And this rather simplified graphic here seeks to focus more around the different business models and the commercialization of the offering. So we might say that at one end of the spectrum, there are the so-called super aggregators that bring together different applications, ways of interacting, and contrasted at the opposite end with marketplaces for bringing together different offerings, but recognizing that the way in which these things interact with commercialization could be very different. What is the role of advertising? What is the role of network effects? How do these platforms make a living? Somewhere in the middle, we may observe transactional type marketplaces where different players will come together across a platform and trade, to use another neutral expression, their offerings with others. And whether the way of monetization is commission-based or through a third party or through sales of ancillary products, or even the main product, so that price-oriented or something else, perhaps leads to a more deeper inquiry that says maybe platforms are the same, certainly when we focus around their economic significance, let alone the extent to which they may be have influence over our lives. And another related contrast being around the extent that platforms access to data where that is part of their brand mission. What indeed is insignificant data, where we often speak of big data, where there is value in consolidating large amounts of information, where the very value is in the magnitude of that data and that hours and so forth. But again, we can see some contrast here in the extent to which these platforms have visibility with data or may not at one end of the screen on the right hand side, whereas others may see this as their raison d'etre and has prompted deeper inquiries as to whether the amalgamation of that data when the platform itself is both a supplier of its own services but a meeting place for other independent parties. What extent does this all seen or visible access to commercially sensitive data or data that can itself be monetized? And then looking at the significance of individual users. As a lawyer, I tend not to like to use the word the owner of the data, but it can be something that individuals of the data subject they have a preference to use. I would rather speak in terms of a rights in and over and in relation to that data in considering whether any of these agents or the subject of the data have any rights over it and the way in which it is used. So having charted that whole landscape and not on the observation at the start that maybe do differ in a more careful appraisal, let's now take a look at the current market economy. And I'm sharing here an insight is probably from a more established vantage point about the new economy. There is something of an oxymoron there, but what it does reveal is an interest in newer economies, newer technologies are radical and really prompts the questions whether the traditional economic tools that we've grown up with, where adaptation, fixed line telephones, mobile phones, are we really talking about the phenomenon here? And do we necessarily need to give up on the traditional regulation simply because we have seen such a mental shift in technology in more recent years? So what is it that prompted this concern about traditional antitrust or regulation not being up when it comes to digital platform? And some of the features that I've observed in some of the national or commentary may be grouped around these 5 ideas, and appreciating the multi-sided nature of the market, that there may be asymmetries in terms of the value transfer and the value gain by different counterparties. I focused also on data and the importance of that, recognizing the fact that utilization or monetization of that data is I think there are parts of them coined the phrase data is the oil to focus on that potential. But on why oil, which was used does not necessarily allow for a multiplicity of users. Benefit, the phenomenon of data does allow for much greater utilisation of the commodity, the benefits of many. So prompting that economic question about rivalrous or non-having goods. The network effects, again, has concerns that these markets alone this results in them tipping towards certain actors. But again, I'm not necessarily expressing a view here on whether I agree with any of these propositions, but certainly to highlight that some of the theories of harm here may not necessarily be that crucial, and are theories that have been expressed for many years. But what is it then that makes digital special? The high level of innovation, practices changing over time, and the fact that the idea of monetization, as consumers may be willing to transact with platforms for no obvious payback. We may be able to share our data, not necessarily expect an economic return. And this idea of value in a more tangible experience is something that perhaps benefits me acquiring. But again, thoughts will remain very much in the mode. But in more recent years, and I have to say the last 3 to 5 years, there has definitely been an incremental shift in terms of the actions area. During lockdown, I found myself writing about artificial intelligence. There's a book on this, or quite radical, even hipster at that point. And now looking at the text that was finalized, realizing just how out of date that is in a matter of years, and really giving that insight in fact that as markets are developing through agencies, governments, regulators, how can they be as is? And the scrutiny that has been brought bear on this, looking at this from an international perspective, we see interest not just by governments in the UK, we'll be looking at an European level, but reviews from authorities, usually Antitrust, broadening their horizons for other areas. Some of these authorities, like the UK, have got a consumer remit. Communications regulators, whether it's the UK or others, is this really an area that naturally sits with them, or the competition regulator? Could there be dedicated authorities? And in some newer environments that I have observed, even dedicated regulators for artificial intelligence in the Middle East. The data regulators, like the Information Commissioner Office in the UK, what role do they have in bringing together other economic regulators? And that's where the Financial Conduct Authority in the UK has entered into arrangements with the Markets Authority, Information Commissioner Office, as well as the patients. So we are certainly seeing increasing scrutiny at all different levels, and not only by economic regulators, but also antitrust. And when it comes to some of the most influential contributions that have been raised, just taking a snapshot over a 5-year horizon, there is voluminous output documenting very similar themes, whether that's from the United States, the United Kingdom, the European Union, and Australia, and recognising that the market authority's interest here was before EU law stopped applying directly in the United Kingdom. So this is, want of a better word, a pre-Brexit reform, and already highlighting the fact that approaches in the United Kingdom today may not necessarily be exactly congruent with those of the European Commission, now that is not a member state of the Union, and as of end of 2020, EU losses in the Kingdom. And the interest in specific companies has shown no sign of abating, and these are just a small handful of investigations into familiar names on the antitrust side, pursuing questions of dominance and so forth, but where we are almost moving away from some of the traditional theories of antitrust harm to the open book, where those who are familiar with EU regulation have a dominant position under Article 102 of the treaty, it is not a closed list. So certain behaviours such as self-preferencing, one's own vertical routes to market, well, that in and of itself be a theory of antitrust harm. And another phenomenon which is specific to the Union is the question of state aid or state subsidies, where any form of subsidy that gives a preferential advantage rather than the state that distort the internal market view needs to be subject to ex-ante approval by the European Commission. And that has prompted at least a fair share of inquiries as to whether certain tax benefits that are given by the member states that may not be available on like terms to other market counterparties are these lawful under the EU state aid rules. So this stylized graphic again seeks to understand the theory of harm being made here. Very broadly speaking, is designed to explore whether a multinational platform that has its headquarters in a member state, would that platform benefit from a mode of taxation which a business does not have that scale, may be operating domestically, and may not be able to achieve arrangements in terms of allocating revenues or geography. The result that the effective tax rate in the member state may be rather low. Why is that being done? The economic benefits of attracting businesses to the country may be quite apparent. And this already comes up with the challenges around what is the relevant reference point when multinationals are occupying global position. What is a normal rate of tax? And what are the but to ensure that entities are paying the fair share of tax, and where should that be? Just to update on the post-Brexit position in the United Kingdom, one of the effects of withdrawal from the UK is that our regime is not analogous to the EU rules in the sense that subsidies need pre-approval and there is a suspensory period. The Subsidy Control Act in the UK has a regime which is between what WTO, World Trade Organization rules, but does not go far as the EU rules in terms of requiring suspension of subsidy approval. But challenge can still ensue, and there is an entity class unit which advises on compatibility of subsidy. So we are very much in an evolving regulatory environment, but just to focus on an area which perhaps is not as prominent as the commentary around specific that platforms can raise. Looking at some investigations at national level, we will also observe some familiar themes here, and I have just shared some examples from Germany and France on measures designed to address some of the concerns that have already been outlined, but already hinting at the use of measures, interim measures, even before the authority has concluded its investigation. So prompting that inquiry, which says that perhaps more anticipatory measures are needed by the time the inquiry has concluded, it could end. So having mapped out those international issues, focusing on some developments in Europe, this now really leads us to focus more on the question of what are the emerging and how might they be addressed. And this is purely an economic harm in terms of market power, or are there a richer series of issues that suggest a much more approach? And who is the right entity to deal with this for? So the question really of all things new application really focuses on the question of the winner-takes all approach. And certainly in Europe, the idea of as efficient competitors has given way in more recent time, perhaps to an inquiry into not as efficient competitors and thinking about whether more needs proactively to support new entrants who may not be able to replicate the same features of players. When we look at calls in the consumers, this really raises about the boundary for intervention here. Are we really concerned with protection or economic terms? Thinking more broadly to other questions about safety, privacy, of minors, for example, this raises that question about where to draw the line. Is there something magical about reaching the age of 13? It tends to be the trigger point the much more intrusive regulation in the data protection space, but also recognising that younger adults may still be vulnerable, and asking from a social responsibility perspective for platforms. The question around the role advertising is almost the digital manifestation firms that were around in the area of print, recognising that in a digitised environment, we are seeing now is economic challenges to traditional print, understanding how advertising revenues are into news sources, the idea of business producers or prosumers. These are not necessarily new ideas, but when they start interacting with the marketplace for ideas and for news, the issue about polarisation of viewpoints and understanding the market share or market creation rules of antitrust may not necessarily correlate with influence over market or ideas. Other concerns here around the ability platform, the concept of being too big to fail is very familiar when we talk about financial markets and systemic harm, but has also given rise to a similar debate platforms about what would be the effects, if any, of these platforms collapse. How can that be? Just to give an example of this, I have a particular client that I work with. Most of our communications place over WhatsApp, sometimes to my frustration. And there was a 24-hour period when that was available, and I did not hear from those at all during that period, or did I hear from anyone else in the geography where they were located, whether that was social, business, or other patients. And it really brought home the significance of that patient platform, which may not have been apparent until it actually failed. During lockdown itself, 5 years ago, I can remember a situation when court proceedings in some geographies, litigation was actually commenced over WhatsApp because it did not have the digital flexibility to deal with it. So needs must in this environment, but does focus very much on the significant failure of any forms. We also look at beyond some of these ideas of economic harm to national security has acquired a much more immediate imperative in recent years, days, even as we speak, an evolving scenario. And certainly from a European perspective, have seen an intensification of this as a phenomenon. When I started out in practice, areas in which national security reviews of mergers in the United Kingdom when transactions triggered our domestic merger control rule. Our public interests were very narrowly defined, broadly to defence of the right media. Over time, we have seen the categories of the interest or national security expanded. Similarly, in Europe, European Union on substance regulation is so wide that can now bite upon subsidies given by third countries to market actors that operate in the European Union. So, and a state in the Middle East giving economic resource to in the United Kingdom. Yes, there has been a complaint about that to the European Commission and has triggered an inquiry on account of the fact that club is active in European leagues. So I share these thoughts simply to highlight that this issue is one which is international, and rather than a more liberal approach, the direction of travel over the geopolitical landscape is one which is intensifying in ways which would not have been anticipated only at the start of my practice, when national security was and other grounds of public interest were narrowly defined, very specific provision made on a case-by-case basis. And the long-arm reach of states to take action outside of their borders in relation to conventional spiral states has certainly seen an exponential increase. But coming back to digital platforms and the question of what is all maybe special about them, and does this really mean that our traditional tools need some agility of mind to deal with some of these phenomena, or do we need some more? And going back to my observations at the start, perhaps fair to say that there is no accepted form, as we've seen with increasingly hybrid models and different monetization strategies. So what that does is it vests a huge amount of power in the drafters of the document, but increasingly creative ways argue that we are proofs. This graphic here looks at the difference between the so-called transaction versus innovation path, but where the crossover of the Venn diagram here shows that we do observe hybrid models. So the difficulty of definition still remains. And the question of whether to regulate, whether to break up, whether to rely on antitrust in itself. It is certainly true to say that the direction of travel, whether it's through the creation of a dedicated digital markets unit or that in the EU, has certainly been towards greater use of ex-ante powers, and not necessarily those that regulate antitrust using the traditional restriction for use of competition, but actually requiring certain platforms to have in place rules, procedures, and treatment of certain fine ways. But looking at this question of should we have a more one-size-fits-all approach, knowing that it may be quite a blunt instrument that has the attraction of simplicity, and accepting that some platforms will argue that they should the code of conduct apply in a more unique manner or tailored to the situation of the market player itself. And again, this is an area where perhaps the greater heterogeneity in UK's approach was that union. We also are observing this question of how to build models of and regulation, algorithmic collusion being a familiar theme, asking whether the key indicators of concern are really fit for purpose in this environment. So again, this question around traditional theories of harm, what are in society? Are consumers confident about these markets? They still engage with them. Why are we so willing to give such vast amounts of data to these platforms? Do it nevertheless, but sometimes we play. And really asking ourselves, how can the traditional goals of antitrust be reconciled with this? Does this invite a consideration whether a loss of confidence in these markets is itself an area of harm that would be calculated or measured in some way to help us understand whether this is a concern at all. We also raised this question about policy interventions, and if there is a more modest plea I would make here is one for intellectual honesty. And as a competition lawyer or an antitrust lawyer, I'm often faced with the ever-expanding task of antitrust regulators, building in adaptability to concerns around climate change. Could we apply a gender-focused lens to these problems at all? Are they even more apt to target certain minority groups than others who cannot participate in a global marketplace, whether that is an economic one or a marketplace for ideas, and particularly where there are well-documented concerns about the lack of role models, could we say influencers for both our sons and daughters, and the obligations of platforms in this area. So I make a more modest plea here for some intellectual honesty here about articulating very carefully what is the problem here. If antitrust, if action, if control over strategic technology or media can invite a consideration of these, then surely that is a healthy approach in provoking those ideas. But at the same time, it should not be at the expense of abandoning a much wider inquiry about what really are the concerns, that these are not just only those for regulators, but a much bigger society challenge. The fast-moving nature of these environments, again, is something that I observed at the start of my talk. And I think this is where growth of technology, when I embarked on study of EU law as a student in late 80s and early 90s. EU law was very exciting to me. You could expand into economics, do things not all other lawyers did. As somebody who is as old as the UK's membership of the European Union, will be doing your work out that. But seeing certainly in my lifetime very stratospheric developments. I did not have a computer when I started out in my professional practice. Today I find myself becoming increasingly paperless. Indicates very, very much the point about today's market share may not necessarily represent tomorrow's market power. And I think this log here, which is already out of date because it does not refer to the names by which certain forms or products here, shows just how quickly you can become out of date. Certainly my blog has become out of date, and maybe I should stick to true. If we just look at the features of search, and this is perhaps a rather convenient cameo case study for bringing together all of these. And when I delivered a similar talk to some of my newer trainees, asking them to come up with the first search engine, what was it? I got a variety of answers to this, and you may try that experiment with some of your friends, colleagues, children, and so forth. But those who come up with Alta Vista may deserve special prizes. But it is interesting in those earlier search engines now have faded into the past, and where we have really seen the long development of search going back many, many years now, and really asks ourselves, why have certain players been able to develop, has it been innovation, quality of products, network externalities, and forth. And if we look at the sort of inquiry that prompted a deeper look at this, just looking at for one example, again, some of these theories around exclusivity obligations are traditional antitrust harm, but others around self-preferencing have pushed the boundaries much further than what, at least in the EU, we had understood to be the traditional toolkit. So search has certainly prompted a much deeper inquiry about how malleable the traditional theories of antitrust. So let's try to bring this up to date here. And I could spend perhaps another hour, day. I have delivered a whole week worth of presentation just on the topic of regulation. And some people were interested in 10 hours a day on this subject for a week. But we do not have a week. So I shall just leave you with a few real-time developments here, which do show that we are seeing some new and we are seeing issues. And this particular example here, on a reference from a member state to the Court of Justice asking about the obligations of a dominant platform, about what do they need to offer for interoperability. And this may well be surprising here. That is not only in the situation where engagement platform is an essentiality in economic terms, but it may be that that platform still needs to offer interoperability on appropriate terms to make the newer entrant or third party app providers proposition more attractive. Humans, a radical thought, they say, which certainly stretches anything that we have known around essential facilities of ports and harbours. The UK digital market regime, which did not become active as quickly as the European Union's regime, is already now in operation, but still very much early days here, but one to watch in terms of just how focused that will be in terms of course ex-ante conduct requirements. So bringing this all together, and at the outset I expressed some circumspection with the ability Antitrust to deal with the multifaceted nature of that have on up. And this is perhaps my top 5 challenges and areas of caution for a fast-moving market, high-tech and search, and the importance of expert evidence and the pitfalls from the European Commission priority guidance is going through developments as we think, and the notion of as efficient capacity will no doubt be refined over the years in terms of understanding just what an entity found to be dominant needs to do to comply with antitrust law. Unsurprisingly, the controversies in this area give rise to very active debates, and I can perhaps guarantee that many listeners to this presentation may have very strong views about this. I have tried to adopt a more neutralised approach to give a number of perspectives, recognising that quite considerably. And the point about catch-up really does give rise to that question of how much in regulation needs to be said, but also the market showing arguments that are often raised by those seeking to resist. And in the context of very much a great agenda on observers of the very much a focus of policy and recognising the global nature phenomenon. So if we are looking at areas of potential research and just nod to the experts out there, whether you are economists, whether you are lawyers, whether you are policymakers, on trying to add to the debate in an area which is highly saturated. So this is my wish list of things that I would like to see produced to try to bring some rationalisation to what is an area where everyone has chipped in their 2 cents worth or 2 pennies worth. My own jurisdiction on what say. The appeal mechanism, I think, is very important in ensuring the rights of defence. Well, of course, I would say that because when I'm not delivering a presentation like this, I am wearing a wig and litigating these issues in front of courts in what is a highly litigated environment. The institutional structures to deal with this gain the insights from institutional economics, I think, have a very valid role to play here. I'm really emphasising a cross-disciplinary approach to these issues, whether it's cyber security, national security, of inspection, and really trying to look at what good look like. How do we measure that? Is it measured in terms of output, pace of innovation, and so forth? But recognizing we may only know that in an ex-post environment and have to rely on modelling then. So that does bring us to grasp this question here of the so-called Collingridge Dilemma, which I would invite the regulators out there who act with some healthy skepticism and not assume nothing, but also to businesses and their advisors on the importance of a very rational theory and evidence-based approach to trying to resist this by having both the arguments, facts, but also the empirical data. Not because it's very easy to say, let's wait and see, but trying to ensure that the approach of business starts with that the theory brings, because there is nothing worse than some theory that just does not work. Practice what make sense. So my final 5 takeaways. It is very clear that there is one thing we can be clear about, and that is a level of interest in the emergence of tech, which we like to call platforms, and a lack of satisfaction with what is being done. Some say there is too much, say there is too much regulation, and how do we find the Goldilocks optimized approach? Is there even a Goldilocks optimized approach at all? And do we be pragmatic about this and say that something that is perfect enough rather than perfect enough? And then I can give large to all of the arena only on that my part book, recognizing the differences. The traditional tools of economists around network effects, economies of scale, certainly do have a role to play here. So we are not abandoning the tool, but focusing still more on behavioural biases and why we behave in the way that we do, notwithstanding we are faced with data that may seem incorrect, but nevertheless we behave in what in the phrase. The definition of a platform may well differ, and having much clarity on what that is for what purpose. Speaking from the United Kingdom and the European Union, though I am based in London, practice around the world, and I'm very much still a full-blooded EU lawyer, and in Ireland, which is the Member States, so feel able to at least some commentary from both my UK and home, but seeing an increasing role here for the aspect of regulation, but working hand in glove with and finally those buzzword catchphrases that I charted at the start. Would we regulate England as a company, or break the top, do nothing? Perhaps the arguments for breakup have become more moderate in recent times, but still the sense in which the regulators be in conservation mode, which is certainly had I given this presentation 5 years ago, just description. Speaking from the EU now, we are in the development much closer to regulate this area. I appreciate that has not necessarily approached the world over, but those are my observations from this side of on. So thank you very much. Attention, and I shall now stop sharing and come into the main room.
Professor Rabb, thank you very much for that extraordinary, comprehensive and well-structured presentation about the regulation of digital platforms in Britain and in Europe. What strikes me is if you had said this was the presentation for the United States, it would be remarkably similar. One approach that antitrust authorities in the United States took, particularly under the Biden administration, was in fact to change the antitrust paradigm. And what developed and is often referred to as hipster antitrust, to move away from a pure focus on consumer welfare to more of a big is bad, almost Brandeisian view of antitrust. Has there been a change in the paradigm in Europe and Britain about looking at antitrust matters in a similar way?
So there's perhaps three observations I would make, and this is, first of all, that whatever the view from observers, we may say that the EU or the UK is perhaps much more pro-competitor than pro-competition, and that somehow the consumer welfare standard may get lost in that. Fact remains that the law as it stands is built very much around a consumer welfare standard which remains applicable of competition for enforcement. In terms of seeing the shifting strands on developments in approach, what we observe with a change of government or a change of the relevant administration in the EU or in the UK is we do not necessarily see a quantum shift just because the politicians have changed. It does not mean that we start rewriting the antitrust rulebook to again. And I am often asked by my US colleagues who do get very interested when things change following elections and new parliaments, thinking, is antitrust going to change? Strictly speaking, we are built around a framework of independent regulators, whether that's in the EU or elsewhere. So it shouldn't really change that much. Yes, the personality of the regulator, somebody at the head of the commission, may give a different flavour or impetus. But I do have to say that I'm speaking from a very personal approach here, that the demands that are being put on law and competition authorities in the UK and in Europe are really stretching that welfare paradigm. And that's where increasingly these authorities are being asked to look at questions which a purist would say, is that really the purview of antitrust? So, for example, climate change, other types of policy areas. And so far there has been a lot of engagement with that, tries to these challenges almost within the traditional toolkit, because some of the themes around cooperation in these areas, it's the standard antitrust toolkit, but applied in this market, but can nevertheless achieve the outcomes if appropriately applied. I think that going forwards, it would be regrettable if any of these agencies do political influence to try to pursue another agenda that doesn't retain that purity. But at the same time, we have to see the world around us. We have to see a real need for growth in all markets, for innovation, for growth of the economy, whether that is the economy I can see outside of the window here in London or much further afield. So I do see increasing in the UK and in Europe that are asking a lot more of regulators and antitrust regulators, both beyond what they have been tasked to do.
Well, Professor Rabb, following up on that, we're recording this in early April 2025, and there is regrettably sort of a looming trade war between the United States and much of the rest of the world. Is that likely to be one of these other areas that are peripheral to antitrust, but which there will be a lot of political pressure on antitrust authorities in both Europe and in the United Kingdom to take into account?
So on the issue of trade, the relevant bodies that deal with trade now, we observe at least more actors on the market. So very broadly speaking, from a tariff perspective, tariffs being agreed on bloc for the EU as a whole presents a rather different environment from the UK's perspective, because now following the EU's report from the European Union, it is for the UK to agree whatever tariffs are imposed and take whatever measures in a more autonomous way. So there is now a new body, the Trade Remedies Authority, and I have certainly observed just in the last week or so, real-time insight on, are there cases happening? Yes, there are. Are they targeting US exporters? Yes, they are doing so. Yeah. So a specific example of part in the race here is the announcement on the 17th of March, St. Patrick's Day. I will say that because of my Irish heritage. But the Trade Remedies Authority did open an investigation into exports of HBO into the UK. Back in 2022, it had relaxed measures that the EU had, broadly speaking, because of the lack of any domestic production in the UK, but has now opened an inquiry where complainants have observed increasing exports from the US into the UK markets. So this is a very fast-moving area, and I would expect to see in the not too distant future some very complex areas to navigate on how respective groups protect their interests and where there may not be absolute congruence in approach around the world.
Professor Rabb, I could keep asking you questions all day. This has just been delightful, but I'm going to encourage our audience to send questions directly to you. They can reach you at Matrix Chambers in London, and you obviously have extraordinary insights into what's going on with regulation in Europe and in the United Kingdom. Thank you so much for taking time today to speak with us here at the Hudson Institute, and we look forward to speaking with you again in the future. Thank you so much.
Thank you very much.